Hi there, my name is Christian Chessman, and this is my 2015 NSDA Nationals topic analysis on the topic Resolved, the benefits of First Amendment protection of anonymous speech outweigh the harms. Now, this topic analysis, like any good debater, includes signposting. So we're going to look at the background into the First Amendment, then we're going to look at affirmative frameworks and strategies, and then negative frameworks and strategies. Because this is a limited format, I do suggest that you look at the full topic analysis in the Champions brief, because that gives you a level of depth that this kind of analysis as a video just can't convey, and the brief itself is full of excellent evidence that I think is important for any debater to have access to, in part because the evidence is good, in part because you know what everyone else is reading, so go get the brief. That said, let's start with the background. So the first question is why you should care about the background of this topic, especially because it's not necessarily cardable. A lot of the concepts and a lot of the information that go into informing a debater's knowledge about the First Amendment don't necessarily translate immediately into arguments. Nonetheless, they're important for a couple of reasons to know. The first is that cross-examination questions can win and lose debates, especially in front of lay judges and older school judges, which are who predominates at the CFL National, at NSDA Nats in a couple of different rounds. So some rounds you might have more lay judges, other rounds you might have a circuit-style judge. You don't want to lose the rounds that have the lay judges simply because they're lay. Having the background helps you to understand how to answer cross-ex questions in those rounds where those cross-ex questions are especially important. So with that said, knowing the background information can help you answer squirrely cross-ex questions and make intelligent cross-applications that your opponent might miss. So if your opponent doesn't understand the relationship between regulating the First Amendment, or doesn't know that the First Amendment does not apply to and does not limit private actors, then the AF can make smart arguments like private actors can still backlash even if the government can't, and that gets out of a lot of negative offense. Now I'm going to discuss that argument in a little more depth in the substantive section, but it's worthwhile to say that background information, especially on legal topics, is profoundly important. So the first is the introduction, and you can organize this around a series of questions. The first is, what is the First Amendment? The First Amendment is one of a series of constitutional amendments that give protections specifically to a series of enumerated rights. The First Amendment protects three rights that are likely pertinent to this debate topic. The first is the right to freedom of speech. The second is the right to actually lobby public officials. And the third is the right to exercise freely your religion. Now, most debaters are going to focus on the speech provision, and it's likely to be intelligent to spend most of your prep looking at that kind of research. Nonetheless, it's actually very important to understand that First Amendment protections encompass much, much more than speech and assembly. In fact, I think clever affirmative cases could include arguments about the importance of religious protections in terms of online free speech, especially in a globalized world, and especially where there are global diasporas of religious groups. So where global religious groups aren't concentrated in one place but are really spread out around the world, anonymous religious speech might be important for those people to find community without facing potential backlash because they practice a religion that is not particularly popular where they're actually physically located. I'm not going to go too much into those arguments because I think that in a limited time it's important to talk about what the core of the topic is likely to be. But it's important to note at the outset that the First Amendment, as an amendment, protects much, much, much more than just speech. So the second question that you should ask yourselves, or that I can ask you, thank you for asking me, is who the First Amendment limits. The First Amendment limits only the federal government and state governments. So what that means for debate rounds is the First Amendment can be in full force, can be completely honored and respected, and does not have to bind or restrict private actors. So I, as a private actor, can say and do whatever I want. I can espouse politically unpopular opinions. I can punish people for espousing politically unpopular opinions. If I was an employer, I could fire someone for holding a politically unpopular opinion. That's okay, even under the First Amendment, because the First Amendment is limited to what the government can and cannot do. And the government, over time and through the development of constitutional law, has come to apply to both the federal government and the state governments, respectively. There are a series of private actors that it may also apply to, but those are very limited and unlikely to apply to any substantive arguments on the topic. Those few exceptions really deal with public or private actors that kind of perform a public function. So everyone remembers the private prisons topic. People that are doing private prisons kind of are standing in the shoes of the state, and so they count. So they can't abridge your First Amendment rights, but pretty much any other private actor can. Bearing that in mind, it's important to note that private actors can backlash. In fact, they can backlash all they want without violating any First Amendment restrictions. So Facebook, for example, could include in its terms of service, if you write anything racist, we're going to ban you and you promise to pay us money. And that might be enforceable. You can certainly give up the ability to speak or limit your ability to speak by contract, and those user agreements are contracts. You can also just be publicly shamed for your specific speech. So that's not a limit on your speech, it's counter speech. So if you say something racist on the internet, someone screenshots that, posts it, and goes, look at this terrible person, they said something racist, you can be publicly shamed. That does not abridge your speech rights. You can even be fired. And that's important to note because it limits a lot of the negatives ground in terms of suggesting that providing First Amendment rights turns the internet into a free-for-all, in part because the internet's already a free-for-all, and in part because there are actual material things that check the ability of that free-for-all to really escalate into something terrible. The next question you should ask yourselves is, who does the First Amendment protect? The First Amendment protects pretty much everybody. The term in the 14th Amendment that describes the scope of due process is person, not citizen. So what that means is people who are not citizens that are in the United States are still subject to the same due process rights that non-citizens are. So illegal immigrants or people who have, undocumented immigrants, or people who are not citizens but are lawfully here, such as lawful permanent residents, are also subject to the protections of the First Amendment. That matters. And by the way, people that are overseas and not U.S. citizens likely are not subject to the protections of the First Amendment, even if the First Amendment was extended to online speech, because they're not persons inside the United States, and so it might be okay to abridge their speech. That matters because extremist groups have been using online anonymous social media to recruit. So anyone that debated at the TOC or on the April topic knows that Daesh, by the way, it should be referred to as Daesh, not ISIS. Anyone that debated the TOC topic knows that Daesh is very commonly recruiting Westerners, and a big way it does that is by using online anonymous social media. Now, the TA that I wrote in the Champions Brief goes into that in a little more depth and examines some evidence and some of the specifics of constitutional law that would pretty much protect the majority of Daesh's actions. But it's suffice to say that the First Amendment, even when applied to online speech, likely doesn't apply to Daesh and groups that are not in the United States and are not U.S. citizens. The next question that you should ask yourself is, how can First Amendment rights be limited? It's really important to note that First Amendment rights, and actually all rights, including fundamental rights, can be limited without losing their protection. For example, you are not deprived of your right to free speech under the First Amendment because you're restricted from having child pornography. Instead, your First Amendment right simply just doesn't encompass the ability to possess child pornography. Rights, even when they are in full force, are balanced against different competing interests and the type of interests that are necessary, again, is discussed in more depth in the topic analysis, but are balanced against competing interests. And it's suffice to say that the United States government, state governments, have a compelling interest in preventing the production of child pornography, and it's so compelling that you're actually allowed to legally abridge the First Amendment. So it's important to note that the First Amendment isn't a free-for-all, unfettered, unqualified right, but rather it's a right that's subject to important and thorough restrictions that prevent a lot of the misconduct negs are gonna want to pin on AFs. If you're the AF, you shouldn't lay back and take online free speech means everyone is doing black market terrible, awful things and oh no, sad puppies. You should explicitly and expressly say that the kinds of things the negative talks about that are terrible are illegal, and if it's illegal, you don't have a First Amendment right to do it. A good benchmark is, if it's illegal right now, it would be illegal to talk about doing on the internet if you were actually planning on doing it. So if murder is illegal, affording First Amendment protection to online anonymous speech still means it's not legal to plan a murder online, even if it's anonymous. Now, you can talk about murder, but you can talk about murder in person, too. If you can't do it in real life, then you can't do it on the internet, even if the internet gets First Amendment speech protections. There really does have to be a good reason to restrict it, though, which might become an issue if the round comes down to something where regulation is less clear-cut. It's very clear-cut that bribery of public officials is not a First Amendment right, that child pornography is not a First Amendment right. And up until now, actually, most campaign finance laws have been regulatable under the First Amendment, though the Citizens United decision has thrown that into some chaos. So a discussion of the protections of free speech might reasonably include a dispute over how far anonymous online donations might go, because those are definitely speech. So be aware of the areas where First Amendment restrictions are disputed as a regular matter, of course. Let's talk framework. This topic is per se framework heavy because there's not a common metric in the literatures that naturally evolves. So the natural literature for the affirmative really is about principles. It's about freedom and justice and making sure that we cite an important Enlightenment philosopher who tells you that rights are always rights and shouldn't be qualified. The kind of principles arguments that the AF's literature base lends itself to are not really consistent as a measure with the negatives literature base, which typically and primarily deals with the consequences of particularized sad impacts. So, for example, a lot of the negatives literature base is going to talk about cyberbullying and the way in which people are pushed to suicide as a result of online anonymous hateful speech. So what happens for a judge is sometimes AF and neg debaters will win their arguments, and the judge doesn't know what to do because there's no framework. So if the AF wins that there is a fundamental right to have free speech, but the neg wins that that free speech will have, or let's say the AF wins a moral duty to endorse free speech, but the neg wins that free speech causes people to commit suicide, what does the judge do with that? The fact that there are multiple reasonable possible answers means that debaters that choose not to answer that question essentially leave the round to a coin flip and the personal preferences of the judge. Instead, what debaters really need to do is outline a framework that encompasses and analyzes the impacts for both sides and explains why the debater comes out ahead. So there are two real ways to compare the two methods to read framework on this topic. The first is to compare the two types of framework between the AF and the neg and argue that the AF's or the neg's is better. And the second is, as the AF or the neg, to argue that you access the other side. Now, this topic is primarily split along the lines of the traditional analytic philosophies of deontology and utilitarianism. Again, if you don't know what those things are, look at the written TA. The Stanford Encyclopedia of Philosophy is also an excellent resource to explain them. The short version is deontology is rule-based ethics and the rules are inviolable. So you shall not kill ever. You can't kill if it would save more people. You can't kill if it would stop someone from being tortured. You can't kill, period, end of story. It's a rule. Consequentialism, by contrast, looks at the consequences, as the name suggests, and instead tells you to judge the moral rightness or wrongness of an action in a context-specific case-by-case scenario by looking at the amount of happiness or sadness that's produced by a particular event or action. So you could say you shouldn't kill unless killing would make a better world, in the sense that the world has less pain or more happiness. So the very, very, very traditional example is if you've got a train coming at people, and on one side of the track you've got one person, on the other side of the track you've got 4 people, and they're all tied to the track, so you can't get them off, but you can flip a switch that would stop the train from hitting the one person, but would make the train hit the 4 people. What do you do? Well, if the train was otherwise, without moving, going to hit the one person, a deontologist would tell you, you can't kill, inaction isn't the same thing. A consequentialist would say, what the hell are you doing? You're going to kill 4 people if you don't move it. Move it. The difference is whether you judge the action as intrinsically wrong or you judge it by its consequences. And that literature, or that philosophical difference, is where you really get a difference. So comparing the two is the first option that you can use. If you want to argue that deontology should be the method by which the judge evaluates the debate, then you should suggest that the negative and their utilitarian approach looks at mere survival, really, rather than flourishing. And deontology aft debaters should suggest that mere survival is meaningless unless there's really a quality to it. There's no reason, the only reason we care about living is that our rights are protected. Rights are the foundation of what gives life value in the first place. We don't really want to merely survive. We want to thrive and flourish. Better to live on your feet, or better to die on your feet than live on your knees, as a sort of thinking. And I think those quality of life arguments really take you a long way, because they suggest that principles are kind of the grounding experience, and that sort of encompasses the consequences that the negative is trying to get at, but does so in a more effective way. Now, if you're trying to argue for utilitarianism first, then we should argue that you really only care about principles because they produce a social utility. So, murder is wrong as a principle, is socially useful to prevent yourself from getting murdered. Same with free speech. We care about free speech because it protects politically unpopular minority groups from the tyranny of the majority, not because there's some intrinsic value to free speech. And so when the tyranny of the majority or other concerns like it aren't at issue, the calculus is kind of different, and free speech thus should be judged on kind of a case-by-case basis. So unless the principle is useful in a consequence sense to apply, it shouldn't be applied. So utilitarian debaters that are on the negative are going to want to argue that kind of thing. Now, you don't have to necessarily argue one framework over the other. Instead, the second option you can take is to win in both frameworks. So it's possible to say, we win impacts in our framework because more people are happy if you vote AF or neg. We also win impacts in their framework because it's the principled and right moral duty to follow our argument. And that way you can go, Judge, look, we have impacts in 2 frameworks. They only have impacts in 1. The second framework is the tiebreaker. If you're not sure, easy way to vote AF. That gives the judge the ability to kind of resolve the question because they have a way to neutralize the offense for the other side and evaluate in your favor that isn't just kind of their arbitrary preference. The last option that you have is just to win in their framework. And this kind of involves jettisoning your case. So if you're really just trucking them on framework, and you don't really want to extend your impacts in your framework, but you want to extend your impacts in their framework, you're fine to do that. So if you started off as the rules person and you end up as the consequences person, you still win the debate because everyone agrees the debate's about consequences. Then it's just comparing between consequences or comparing between rules and the significance of the rules, things like that. Let's jump to AF arguments. The main AF argument is going to deal with whether or not you should give primary interest to the principles involved in supporting free speech. So this is going to draw from a variety of Enlightenment philosophy that your school's LDers are probably familiar with. 3 really important philosophies are the Lockean social contract, straight-up Kant, and rule utility. The social contract is an argument that there's an implicit agreement in society to abide by a set of ground rules, and those ground rules are what kind of controls what government can and can't do and what government must and must not do, and that those ground rules dictate a particular set of actions. Kant is the guy that made up deontology. He's the rules guy and says that you have to follow the rules that are morally right. And then rule utility kind of is a blending of utilitarianism and deontology. It's actually my personal political philosophy. It's very valuable to read up on. Second category of AF argument I think that might be useful is by citing to revolutionary minority movements. And what I mean by that is there are political activist groups that the negative is likely to isolate as being targeted. And you can suggest as the affirmative that those groups actually benefit physically and in like a consequentialist sense from having anonymous online speech. So the neg might go, online anonymous speech allows cyberbullying that harasses gay children. The AF can actually respond that online anonymous speech allows gay people to find an online anonymous community where they don't have to out themselves publicly, but they can still find support. So if they're anonymous, they actually kind of get a benefit. In fact, you could even call it a revolutionary benefit from having anonymous online speech that really helps them out. That, I think, is really important because it throws back against some of the neg's strongest arguments by pointing out that anonymous online speech might actually materially benefit the specific people that the negative is likely to point out. So smart AF might find specific examples that are beneficial that apply to the core negative arguments. You could just, the third main type of thing is other particular examples in general. So you could pick places where, specific instances where online free speech might be valuable. You could pick any number of examples. And an example I actually heard bandied around was WikiLeaks. And it's really important to understand why the background of the First Amendment is relevant, because WikiLeaks is not protected by the First Amendment because the First Amendment right is balanced against the national security interest, and the national security interest wins every day and twice on Sunday. So you need to be careful in picking your examples, but you can pick particular examples and go, this thing that happened was really important and relied on free speech, or this thing that's going to happen is really important and relies on free speech, and weigh like that. And I think the last main type of AF argument is that regulation solves. So the AF can really aggressively suggest that heavy state government and federal government regulation prevents like the ugliest negative examples from manifesting themselves. There are hate crime laws that kind of would still apply even under the First Amendment that would apply online. And since there's really easily the ability to find most online speech's original source, there's really not as much of a risk as the negative might want to portray. And so you could affirmatively allege that as the affirmative by suggesting that regulations solve. You could also just wait till rebuttals and go for it there. Neg arguments. Best neg argument is cyberbullying, and it's not even close. I think the best way to frame cyberbullying arguments is to do so in terms of identifying discrete vulnerable groups. So the few that I identified were children, women, racial minorities, and queer people. The first one, cyberbullying of children, a lot of literature on abusing and attacking and going after teenagers who were in middle school or high school and ended up causing them to commit suicide. A lot of that is facilitated by the online nature of the speech and the anonymous nature of the speech, because people don't say things like that to each other, either when their name's tied to it or when it's in person. And so online anonymous speech might uniquely exacerbate that, especially if it's actually protected by the First Amendment. Same thing with the cyberbullying and harassment of women. My favorite online rule is Lewis's Law, which states that the comments on any internet article about feminism justify the need for feminism. It's not uncommon for people who are either women or expressly feminist to receive rape and death threats. And those are really powerful negative arguments, and they need to be handled carefully, because you don't just want to glibly talk about those things. You need to have a gravity to them when you discuss them. But both of those things are very, very serious and very, very discussed, especially in the wake of Gamergate, which is something you should read up on if you're not familiar with it. There's a lot of really aggressive negative attention that you are likely to get online if you're female. And that kind of attention is likely exacerbated by stronger protections to do so without consequences, which is what anonymous free speech might just do. Again, same thing, basic argument with the harassment of people that are racial minorities. I read an article actually just yesterday. President Obama got a personal Twitter, and 10 minutes after he did, he was tagged in, I want to say, a couple dozen tweets that said, "Hello, N-word." First 10 minutes. President of the United States. It's much, 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 much likelier that those people that are doing that, even when there's a huge consequence on the line, because a lot of them got called out in very public articles, when it's just another person who doesn't hold high political office, it's very likely that those kind of actions are going to occur and occur in a way that is terribly traumatic to people. So it might actually be worthwhile to point out that there are meaningful social harms that result from giving broad discretion to people being assholes online. And the last is the harassment of LGBT people. Being outed, especially against your will, is really hard. It's something that constantly happens for LGBT people because you don't just make a declaration to the world. You kind of repeatedly tell people, especially as people come into your life new. You tell your family, you tell your friends, you tell your close friends, you tell your far friends, you tell new people that you meet, new friends that you meet, new partner, just a lot of constant coming outs. And so being outed or being harassed about being gay is something that is likely to be particularly vulnerable to the harassment that online free speech would facilitate. And so it's worthwhile to look at the kind of examples in literature that deal with that when looking at kinds of particular examples. The other really important, really cool neg argument that I thought about was whether Daesh was using online anonymous free speech to recruit, and they are pretty heavily, actually, people in the United States. And the First Amendment protections certainly apply to the people talking to Daesh. So if you have a United States citizen talking to Daesh saying, I'm really interested, I think you do good things, I hope you're successful, I hope you're successful soon, I want you to be successful soon. All of those things are protected by the First Amendment, and it's clear. Those are not controversial things to say. You are allowed to hate the U.S. government. You're allowed to openly hate the U.S. government. In fact, if you look in the brief in my topic analysis, I cite to several cases where the United States government's Supreme Court held, even if you're actively planning against the United States, if it's not imminent, you're allowed to do it. So you can actually specifically plan the violent downfall of the United States as long as it's not going to happen anytime soon. That means that First Amendment protections of online speech facilitate the modern terrorist organization, which is most obviously manifest by Daesh in the modern era. And you can suggest that that kind of thing is going to increase as social media's relevance and prevalence increases. So, like, back when Al-Qaeda was a thing in 2001, the internet was not quite so social media saturated as it is right now. And a big part of the reason that Daesh is doing it is because that social media is available. So as the social media becomes increasingly available, increasingly important, it's going to play an increasingly big role in the coordination of international and national terrorist efforts. And the strategic value of this position is, one, it's unique as all get out. Two, you can recycle a lot of your cards from April, and that saves some time. And three, it really forces a complicated thinking about the topic that I think will resonate with both lay judges and flow judges, because lay judges are going to go, oh no, Daesh, or ISIS probably, and flow judges are going to go, that's really clever, I like your arguments. And there's a really good literature base on it too that just talks about the relationship between Daesh and online anonymous social media, and that is a really solid place to start. I'm not sure how many other media movements are, or how many other terrorist movements using media, but it would be worth looking into those to see what kind of people and places are relying on those social media. So to recap, it's really important to understand the background of the First Amendment, who it limits, who it doesn't, who it protects, who it doesn't. It's important to understand when and why you can regulate First Amendment rights. It's important to understand the relationship between those regulations and the AF and neg on this topic. The other thing that debaters need to keep in mind is that framework is perhaps the most important thing that you could invest time into writing on this topic, because the argument impacts do not lend themselves to comparison naturally, and debaters that read framework well uniformly win at the national level. When I say read framework well, I mean they give it more development than an observation at the top of your case that's one sentence long that you don't talk about except in rebuttal to go, nah, really aggressively in cross-examination. Instead, you really want to talk about framework, and then you need to win what your framework is, why your framework works, and how your framework wins you the debate given the arguments you've won. So you can't just say, we win framework, we win our contention. You need to apply the framework to your contentions and explain how your contentions meet your framework. That's really important, and I think the place where the least analysis in modern debate PF is done, and that's really what needs to be done. Once you've got your background and once you've got your framework, you should consider both the affirmative and the negative. I think specific examples and specific grouped examples are going to play a really big role in determining debates on this topic, especially because they lend themselves to very, very powerful emotive appeals that are also substantive, which gives cases the ability to be versatilely lay and circuit oriented. Given those types of orientations, I think that debaters should bear them in mind on the topic. Good luck and do well. I hope you read the rest of the brief and have a wonderful NSDA Nats.